Welcome, and thank you for joining us for today's PENTalk. If you have any questions during the presentation, please submit them through the question box. We'll answer as many questions at the end as time allows. If we don't get to your questions today, we will follow up with you afterwards. Tomorrow, you will receive an email with a link to replay today's broadcast. Now let's get started. Hosting today is Kim Congelosi, Senior Consultant at Pentegra. Kim is going to provide an overview to prevent, prepare, and protect a retirement plan from a DOL audit. I'll now hand things off to you, Kim.
Well, thank you. I appreciate you coming today and listening in. This is a very important subject that hopefully many of you take seriously. It is essential to understand that any plan of any size can be audited. So it's really important that we understand how to prevent, prepare, and protect our clients and ourselves from these situations. So there's a brief bio of me on the screen, and I have actually worked at the U.S. Department of Labor for several years in the Employee Benefit Security Administration, where I actually did a lot of audits, and I can't even tell you how many people did not understand that they could be audited if they were under 100 participants, or that they could be audited if they were small plans or startup plans. Any of those reasons that people think they can't be audited, the unfortunate answer to that is yes, they can. I have been in the industry for a very, very long time, and I could say I started when I was 12, which I'm sure you've all heard. But I have been in the industry for over 30 years. So I have worked on all sides of retirement plans, including operations, relationship management. I was an advisor. I have been a client. I've done everything from starting a trust department to working as a consultant here at Pentegra. So I just wanted to give you a little bit about myself. And so let's get started. So today we're going to talk about the prevention of the audit process and whose roles and responsibilities it comes down to if and when you are audited. What to expect and how to prepare for it. And we can go over how to keep your files and what files are important, what files are not. And then finally, how we can protect your company and your clients, both personally and company-wise, from being audited, and a way to prevent yourself from being audited again in the future. And there will be a fourth P that we're going to talk about in a few moments, but that's a special P, and I saved that for last. So preventing an audit can be done. The most important way to do that is to state that you do not have late contributions. So don't have them. If you correct them during the year, you do not have to mark them on your 5500 as being late anymore. You can mark that you went through a correction process if you'd like to, but be consistent. It is essentially important that when you make your contributions, if you make them 3 days after payroll, make them always 3 days after payroll. If you make them 2 days after payroll, always make them 2 days after payroll. Otherwise, you can be, they can see that you can do them 2 days after payroll, but for some reason, 1 week or 1 payroll period or 5 payroll periods, you made them after 3 days. And so that's very essential because you will be fined, or you could be fined, but you will definitely have to pay the interest on that 1 day for each participant contribution that was late. So it's pretty crazy, but it is really completely arbitrary. When you're doing your interviews with the investigator, they will ask you certain questions that will back them into how many days it should take you and how many days it does take you. If you always did it 5 days after payroll because maybe that's something somebody told you, or you had until the 15th of the month following the month in which you were finished, or in which you made your payroll, those are both incorrect. You can be required based on what your abilities are or what your system capabilities are, to make your contributions after 2 days or after 3 days. That's what you'll be held accountable for. It is also essential that you do annual reviews with your provider, if possible, especially even if you do them via WebEx or if you do them in person. But one of the things I highly recommend is getting a signed affidavit of who actually attended the meetings and keep that in your folder. And the reason for that is they can show who was at the meeting, and it's essential to see that all of the fiduciaries attended the meeting for any amount of, even if they're just the payroll person, or even if they're an ERISA attorney, whoever is making decisions on your plan should be attending your meeting if possible. And if you said that you were going to take action, or you said you were going to change your fund, or you say you're going to increase your match, whatever it is, take that action. If you say you're going to take that action, they're going to follow up to make sure you actually did do that. And that fourth P we were talking about is this one. It is process. Create a written process for your plan. For example, payrolls are done 3 days following payroll because, and you can put in there why you took you 3 days or why it takes you 3 days to get those payrolls into the system. If it takes you less than that, then create that process and do it. And the process idea follows everything. If you have a process for distributions, write down your process for distributions. If you have a process for hardships, if you have a process for enrollment or for eligibility, make sure you have a written process and you follow it. And a lot of people think that their summary plan description or their plan documents or amendments will qualify for this, and that is not the case. If you are audited by a Department of Labor investigator, they will look for a written process. Even if your process is wrong or your process is longer than it takes you, that is still fine, because as long as you have a written process and you follow it, you will be held in compliance with the law as long as you do that. So it's really the biggest thing. If you take away anything from today, take away the fact that you must have that written process and you must follow it to a T. It's kind of like the investment policy statements that people had, several years ago. And when they had those policies, they thought all they had to do was have the investment policy statement. But the real process is that if you have an investment policy statement, you have to follow it. If you have a written policy statement and you don't follow it, you're actually better off not having an investment policy statement. So it's better to have no process if you're not going to follow it, but it is really important that if you can, have that written process, follow it. Same with your investment policy statement. So we're going to ask you a question now. So how many of you know your plan document and your policies and all of their provisions and work on the plan to employ them on a daily basis?
We will be closing the poll in about 15 seconds. So the results look like 58% of you know your client's plan document and the provisions, while 32% know some of your client's plans and document provisions, and 10% are not confident or employ either really well.
Great. Well, that's great information for you to know that most of you are, or close to most of you are, following your plan document provisions. But if you don't or you're not, I would highly recommend going through your plan document or going through your adoption agreement and creating like a quick, sheet of all the provisions that are in the plan. Like, this is the match, this is the, the hardship withdrawals, this is how, and then how you handle all of those things. That is essential, and it's probably one of the first things that will be asked of you if you ever are audited. So again, we're still talking about prevent, and we're talking about the process. Gotta go back one. Okay, so if you're protecting your plan and your document and yourself, because you are protecting yourself, because as a fiduciary, you can be held personally and severably liable, which means that not only can the client come back to you if you don't have a 316 or a 338 on your plan, you have to protect your process because you have to protect yourself. So you document all of your processes, like we just said. Keep a file of the documents, amendments, distributions, contributions, the fee disclosures that you receive, and all notices. And that will show that you were able to send out your notices on a regular basis, and that you have your documents and their amendments that came with them. The distributions, and if you get a confirmation of that distribution, and the same with your contribution, if you get a confirmation of that contribution, I would just, or you could just write on there, if that's your process, submitted on, April 25th, 2023. That will help you and will protect you from getting any kind of litigation around any of those items. It is also important to get together with as many fiduciaries as you can on a plan, because you will get asked the same questions, and they're going to be looking for consistencies. So questions like, who does the payroll when so-and-so is out? Who handles distributions when so-and-so is out? Who makes the plan decisions? Who makes the investment decisions? And they will ask each one of you those questions. And there may be more fiduciaries on the plan than you think. Anybody who makes a decision surrounding anything, especially money, on the plan will be held accountable as a fiduciary. So the person who makes those contributions will be held accountable as a fiduciary, not because they're making the contributions, but because they're determining the date that those contributions were made. So again, consistency is the most important thing. So when we talk about protective services, I mentioned it a moment ago, there are two different types of protective services. There are 316 and 338. And when we talk about the 316, we're talking about the plan administrator. That's usually somebody at the company that you might have now, who basically signed the documents and said, I will act as the plan administrator. They are responsible for reviewing all distributions and making sure they're in accordance with the ERISA laws and the plan document. So if your person is taking a hardship and you have in your document that you're following the safe harbor provisions of a hardship distribution, you should make sure that you have knowledge of what those hardship provisions are and making sure that that distribution is in accordance with those. It is also essential that you ensure all notices are distributed. It is crazy how many people or how much the notices are missed, or they're late, or they're not the correct notices. If you can make sure that those notices are sent out to your employees, and they can be done via email or paper, that's up to you, but it is essential that those notices are being distributed, because if you don't distribute the notices, and let's say a notice that has to do with the fees surrounding the plan, if that notice is not handed out in a timely manner, if a fund changes its price or something else, those notices are being charged or fined at a very, very high rate. Last I saw, it was $1,500 a day per person, up to, I believe, $15,000 a day. So when you're talking about ensuring notices being distributed, it is essential that those get out when they're supposed to get out. Another thing is managing eligibility and notifying new employees when they're eligible. A lot of times people don't have eligibility on their plan for 3 months, 6 months, and then it's following the month, or following the quarter, or, following the next plan year. All of those things are essential that you do manage the eligibility and let those new employees know when they are eligible, maybe 30 days, 15 days or so, either one before their actual eligibility date. And the reason for that is you want to give them time to enroll in the plan. So it's essential that you let employees know when they are eligible and give them a way to enroll in the plan, whether that's via hard copy or online enrollment. And as a plan administrator, if you hire a 316, that person or that organization must be a registered investment advisor, a bank, or a trust company, and they will be a true fiduciary on the plan and all of its documents. So they are held as accountable as the plan sponsor. If you hire a 316, make sure that you are aware of all of the services that they provide. I can't tell you how many times I've run across situations where a plan thinks that it has a 316, and in actuality, they received a notice of all the services that will be provided under that 316, and that is not inclusive. There's about 150 different services that a plan administrator can do, and if they're giving you a list of maybe 10 that they provide, they are not a true 316, or they are only a 316 on specific services. So it is essential that when you find a 316 to hire for your plan, and Pentegra does act in that capacity, that you utilize or you determine all of the services that that plan administrator takes on as your 316. And a 338 is an investment manager. That is somebody is not necessarily have to be your investment advisor, but it can be an investment manager. And investment advisors do act in this capacity as well. So they help to set up investment policy statements, which we talked about a little bit earlier, setting up that investment policy statement and making sure the funds match the investment policy statement. If your investment policy statement says that you have a growth, value, and bond fund in each of the small, mid, and large cap cases, make sure that you have each one of those in the plan. And you don't have 3 real estate funds, 6 international funds, a stable value fund, and 1 large cap growth fund. That's not going to manage to the investment policy statement. Also, when that fund isn't performing according to the investment policy statement as it states, it could say 6 quarters, it can state 9 quarters, it can state 3 quarters. Whatever it is, it has to be put on a watch list and removed when the fund is not meeting the investment policy statement. That is another thing that your investment manager does. And they take full fiduciary responsibilities for this function. So if there is a fund that is not performing in your plan, and it has been that way for, let's say 6 quarters, and your investment policy statement says that it will be removed after 3 quarters of being on a watch list, the fiduciary or the investment manager, the 338, is held responsible for that function. And so we have a case study, and we talked about before how plan provisions are not optional. Now, when we were doing a large prospective client had over 300 employees in it, and we did a review, as we always do with our plans as they come on board, and our team noted that the plan document included auto enrollment. And when we were talking with the director of HR, they said, yes, but we've never used it. So that's a very, very clear case of not following your plan document. So when a provision is including your plan document, it is not optional. So if you want it to be optional, or if you want it to not be included in your plan, do not include it in your plan document. But having it and not using it is worse than not having it at all. So we were asked at the time to resolve the issue. So that means you have to go back to all of the employees who were or eligible for auto enrollment and let them know the situation. And it's a multiple year review because you have people going back to all the way back to when the plan document amended itself to allow for auto enrollment. And you basically have to determine whether that employee was enrolled in the plan or they weren't. And if the employee had affirmed either positively or negatively that they wanted to be in the plan. So even if you don't have auto enrollment, I would highly recommend getting an enrollment form filled out by each of your employees when they become eligible. And even if they do not want to participate, have them put a 0 in the deferral amount so that you have a specific form that says that we do not want to participate. But in this situation, when we had auto enrollment and they weren't participating, it was an even bigger problem because we not only had to have their affirmation that they did not want to participate or they did want to participate. If they did, we had to go back and give them the option to choose to participate currently or to go back. And if we did go back, the plan had to be held responsible for all of the missed earnings that they had. So it's not just a correction, but it's the time and the disruption that these types of mistakes can cost you as the employer and as the advisor, because they're looking to you, advisor, whether or not you're helping them with the services or not. They're still looking at you as the expert. So when you have a 316 fiduciary, they ensure that all the provisions of the plan document are being followed. So it's like we said, compliance confidence. It's making sure that each of the employees that are supposed to be in the plan are in the plan, and that nobody is in the plan that shouldn't be in the plan, because that happens too. They just enroll everybody not based on the enrollment dates in the plan document, or you have an employee who pushes back and states that they want to be in the plan now. They don't want to wait 3 months, and they certainly don't want to wait a year for the match. That they can join the plan right now. Well, that's not the case. So remember, it's compliance confidence in having that 316 fiduciary. So with that being said, I took us right till 5 minutes before the close of the meeting, but does anybody have any questions that I'd be able to answer for you to help you with your plan to protect your plan from preventing, preparing, and protecting your plan from that DOL audit?
Hey, Kim, we do have a question. What does the 316 really do to protect us? Does it take all the fiduciary responsibility away from us?
No, that's a great question. The only things that as a fiduciary the plan would have to do if they were 316 with Pentegra is they have to provide us good data, they have to provide us the payrolls, and they hire us. So that's what they're held accountable for. Everything else is on the shoulders of the fiduciary, which is, or the plan administrator, which is, in this case, would be Pentegra. I hope that answers your question. Does anybody else have a question?
Looks like we have another one. How will this change what responsibilities I still have, and what are they?
Well, it depends on what your role is. If you are the plan administrator on the plan and you hire a 316 to be it on your plan, you do not have to verify distributions anymore. You do not have to verify that your contributions go in unless you have a 180 payroll provider. You just have to then approve the contribution and set it in. Other than that, you really will not have to do very much regarding the plan except submitting contributions, submitting censuses as needed for administrative purposes, and again, overseeing us. That's how your life would change. So anything that you're doing now, otherwise, verifying eligibility, making sure people are in the plan, making sure you have beneficiaries, all of that falls on the shoulders of the 316.
Okay, thank you. And we have one last one. Who will act on the items in the 316? Is it just creating more work for us?
No, actually there is a person or there's a team assigned at Pentegra to act in this capacity, and they monitor the record keeping system to see if there's any hardships in the plan, any distributions in the plan, anything that comes in via hard copy or online, they would manage that for the company. So it's not like you would have to do any additional work. It's actually less work for you, considerably less work for you actually if you're the plan administrator. So they would get everybody who's eligible enrolled in the plan. They would be responsible for distributing all notices. They'd be responsible for making sure that every person in the plan is aware of what's going on and receives a summary plan description. It's really taking all of that responsibility off your shoulders. So, any other questions? Okay, great. Well, hopefully everybody will receive a copy of this tomorrow, like they said. And if you have any questions, please feel free to contact us at 1-800-872-3473 or visit us at www.pentegra.com. Again, my name was Kim Cangelosi, and if you ever need any help or assistance with this, I'd be happy to help you as well.
All right, great. Thank you so much, Kim, and thank you everyone for attending.